Hey everybody, it's so great to see you. Thanks for coming out on this beautiful evening. I'm so excited to be sitting here with Gillian. I want to start out, actually let me ask you this. The book is out in paperback, it's been out in hardcover for a while. I don't mean to shame anyone, I'm just curious because it will help us figure out how to talk about this. Have you read the book? Raise your hand. Awesome. Okay, so a nice mix. Everybody should read the book, paperback or hardcover. It's beautifully realized. It's so intellectually rigorous, and it's incredibly relevant to our time. So pick it up.
Thank you.
Okay, so I'm going to start out. For those who may not be familiar, Because of Sex is about Title VII, and it's about the women who changed the workforce. But what is Title VII?
So Title VII is the section of the 1964 Civil Rights Act that deals with equal opportunity in employment. Most people are really familiar with the 64 Civil Rights Act as the culmination of decades of agitation by African Americans for their civil rights, but they're less familiar with this part of it, the sex discrimination portion. So there are different sections that are called titles within Title VII, and one deals with housing, one deals with public accommodation, and several others. One deals with education, I think, and then employment is Title VII. And as originally written, Title VII prohibited discrimination in employment on the basis of race, national origin, color, and religion. But on the very last day of floor debate in the House, a virulent racist, an opponent of the 64 Act, Howard Smith of Virginia, took to the floor and said he wanted to add sex to the list of protected characteristics. A lot of people have argued that he did it as a joke or did it as a way to sink the bill, because maybe people would vote for a bill that advanced African Americans' rights, but women's rights, come on, that was unthinkable. But like most realities, it's a little more complicated than that, and scholarship seems to have concluded that really he urged on by the National Women's Party, which was pressing the Equal Rights Amendment, and Howard Smith, incongruously, was a supporter of the Equal Rights Amendment. The National Women's Party came to him and said, look, if we have equal rights for African Americans in the workplace, that means black men and black women are going to have more protection than white women. And Smith didn't like the sound of that and proposed the amendment. He also joined forces with some women in the House, notably Martha Griffiths from Michigan, who wanted to add sex to the list of characteristics. So they sort of made strange bedfellows and got the amendment included. But that meant that there wasn't extensive legislative history about what sex discrimination meant, what they meant to outlaw with Title VII's sex provision. And so, there were no committee reports, there had been no hearings, there were no amendments that had been proposed or defeated. And so it really fell to the courts, to the Equal Employment Opportunity Commission, the EEOC, which was created by the act to enforce the law, and then to individual women to give shape to these three little words: discrimination because of sex shall be illegal. The one other thing I just wanted to mention really quickly is that the EEOC was not friendly to this bill, or to this law. The first director of the EEOC declared it a fluke that was conceived out of wedlock. So although I later went to work at the EEOC, and I'm very proud of my tenure there, and the agency has become quite a positive force for pushing the law forward, in the early years after Title VII's enactment, it was especially important that individual women step forward to define what sex discrimination was, given that we lived in a Mad Men world of separate want ads for men and women. Flight attendants could be fired if they got married or gained a few pounds, or once they reached age 30. What on earth did equality look like in the workplace, given that reality?
Right, and it seems like one thing that's really wonderful about the book is it takes us, each story of each woman takes us through the steps of, well, what is because of sex? You know, if you ban married women, if you ban the mothers of small children, is saying I will fire you unless you have sex with me and you're the boss, is that because of sex, or just, sometimes people like to have sex with their subordinates?
Right.
And it's amazing how in these women's lived experiences you see the fact that the influence of gender is much more complex. It's sort of manifested in different ways. So what's kind of the arc then of the women that you tell the stories of and how does that sort of track the evolution of how we understand what sex discrimination is?
Well, I think all the cases in the book, and there are 10 cases that I picked, they're all Supreme Court cases, so it's 10 chapters, 10 cases. And I think they sort of fall into 3 general thematic categories, which really are are aspects of women's identities then and now that have consistently conflicted with their identities as workers, very broadly speaking. And one of those categories is pregnancy and motherhood, which continues to be an enormous barrier to women in the workplace, but especially in 1964, it was, the Supreme Court had just recently held that women shouldn't be recruited for jury service because they were needed at home more than they were needed to serve on juries. So pregnancy and motherhood, stereotypes, sort of larger stereotypes about what kinds of jobs men and women should hold. I mean, separate want ads suggest that there was a realm that was for men and a realm that was for women in the workplace. And then sexual harassment, which, as you alluded to, which didn't even have a name in 1964, let alone have any sort of conception as being, against the law, as opposed to just the way things are when men and women get together in the workplace. So the 10 cases sort of, I think, track those issues again and again, and of course all of those issues are still with us as well, albeit in somewhat more advanced or subtle forms in some cases. But then the arc of the book, I went in chronological order because I thought, and I toyed with lots of different things. I thought about clustering them by theme. I thought about trying to pick cases where this was definitely something also that came up from the publishers. Can we have, the same cast of characters popping up in every, and it was really, I mean, this is a wonky endeavor at heart, and I wanted it to track how the law had developed.
The soap opera of sex discrimination.
That's right, exactly. Stay tuned in the next chapter. So I went in chronological order so that you could see the first few chapters really have to do with, are the earliest Title VII cases, and so they have to do with the most overt formal discrimination that was still in place. I mean, most of the 50 states had laws, for instance, prohibiting women from holding certain jobs because they were considered too strenuous or too dirty or too otherwise incompatible with their lives as baby machines. So the first case in the book is about Ida Phillips, who was denied a job on an assembly line in 1966 Florida because she had a child under the age of 5, and the company had a policy of not hiring women with preschool-age children. Fathers with preschool-age children they would hire, but it was based on the stereotype that women with small children were simply just unreliable and would be absent more and late more and would not be committed. Then the next case in the book is about policies that kept women out of being prison guards in Alabama. Obviously in the mid-70s, anywhere in the country, but especially in places where, as Kim Rawlinson, the woman featured in the chapter, said, where very traditional Southern femininity was expected of her. She decided to challenge the height and weight requirement that kept most women out of that job. And then, again in the late 70s, just a year later, is the case brought by the women of the California Department of Water and Power, who were required to contribute out of every paycheck more to their pension fund because actuarial tables showed that women lived longer than men. So women had to subsidize their own retirements regardless of their own risk factors or how long they were projected to live. And all of these were struck down. So that's the arc, is that we start with these more kind of overt barriers. Then we move into, sexual harassment being identified in the mid-'80s as sex discrimination, not just the way things are. And the courts had been starting at that point to move to understand that quid pro quo harassment, so harassment that has an impact on your pocketbook, right? The supervisor propositions the subordinate says no, subordinate is fired. Courts had just started in the late 70s to kind of get, okay, that sounds like an unfair burden on women that men don't face because of sex. Okay, but this idea of harassment being part of the environment, discrimination stemming from the environment that you worked in if you didn't have any sort of adverse paycheck.
Right, and even if it wasn't the boss, right? Even if it was your colleagues, but it was being tolerated by management.
That's right. And so sexual harassment has been, there are 2 cases in the book detailing the development of the sexual harassment doctrine. And then with pregnancy, the final sort of evolution, we had a case in 1991. I mean, I had just graduated from college when it was decided, 1991. The women of Johnson Controls, which was a battery manufacturer, were told by the employer that they couldn't hold a job that involved contact with lead, which of course were the jobs that paid the best, unless they could prove they were infertile. And this wasn't just that they were going to take the women's word for it. I don't want to become pregnant. I don't plan on becoming pregnant. Trust me, I'm taking steps so that I will not become pregnant. That wasn't good enough. The company viewed these women as potentially pregnant at all times. And so some women got their tubes tied, got themselves sterilized so they could keep these high-paying jobs. And others took the demotion and they went to being basically janitors in these factories. And the Supreme Court struck that down and said, this is for women to decide, what kinds of risks to take and what is more important to them, their paycheck or, their decision about whether to have a family. And just finally to conclude, sort of moving from that kind of barrier, like looking at women as potentially pregnant, future mothers, above all, moving from that to the Young versus UPS decision, which is the final case in the book, the most recent one, decided in 2015, which involved Peggy Young, who was a truck driver for UPS and had a lifting restriction imposed during pregnancy, and that meant that occasionally she wouldn't be able to lift certain packages she was charged with delivering, and the company put her out on unpaid leave. They wouldn't give her a desk job or excuse her from lifting or otherwise make it possible for her to continue earning during her pregnancy. And so in a way, it's sort of the bookend to Johnson Controls, right? Because Johnson Controls is, don't keep us from opportunities because of our physical capacities. Let us do dangerous jobs. So anytime you see a firefighter or a police officer who's a woman or construction worker, you have the women of Johnson Controls in part to thank. But then the reality is that now that women are in dangerous jobs or they're in low-wage jobs that involve them standing for long periods of time or doing heavy lifting of boxes or things like that, walking, climbing on ladders, or being police officers or firefighters, that they might have very real limitations, physical limitations, because pregnancy is a major medical event. And there's a great resistance that I see every day in my work that showed up in the UPS case, and that frankly continues. So the extent to which employers are obligated to accommodate, the physical limitations that come with pregnancy in the same way they are required under the ADA to accommodate. So I guess that arc is from the very, obvious sort of bans on women doing certain kinds of work, or obvious bans on women because of their status, such as being mothers, and moving to more now into, especially when it comes to pregnancy, how do those two identities, mother and employee, coexist?
Right, and it's interesting because there's a current that goes all the way through, at least right until the end. I having written about Justice Ginsburg's cases too, is this idea of women are different and the law must treat women differently, but that doesn't imply a judgment of subordination. That doesn't necessarily mean, under this thinking, under the rationales of the laws and regulations that were being challenged, it was we have to treat women differently because not because they're bad or because they're lesser, but because they're special, should be on a pedestal, are mothers, are potentially mothers at any given point, except if they are mothers, in which case we don't give them accommodations. But it's interesting. I mean, I want to talk about this later, but I can't help but think about having finally sat down and read the entire Google manifesto today. I assume everyone in this room has at least heard about this guy who was fired from Google for sending to all of his colleagues his thoughts about women's capacities and the company's diversity efforts. And there is the same current there, which is that I'm not, and you know, there's still a kind of like interpretation split if you see the reception to this, where some people are saying, but he didn't say that women are inferior. He just said that they're different and really bad at the jobs that are prestigious and pay well. You know, so I'm just saying that they're really cooperative and wonderful and shouldn't be working with me. And so
neurotic, so anxious and neurotic, those ladies.
So how do you? I mean, you're also a practitioner. You know, what do you do with that when people say, "But I'm not sexist. I'm just recognizing women's specialness." You know, I mean, and how has that evolved over time?
Oh, I think as that manifesto shows, it hasn't really evolved over time. Actually, one of the cases featured in your book, you know, that Justice Ginsburg argued to the court, and the court eventually decided, Frontiero v. Richardson, has a wonderful quote in it surveying the history of jurisprudence involving women. And women being placed on a pedestal, and I'm paraphrasing, you probably know the exact wording, but where the justices say, actually women haven't been on a pedestal, they've been in a cage. And with these rulings, where we've been saying how special and precious they are. And it's the same thing, but dressed up in more, hey, I'm a liberal guy packaging.
I love my wife, I love my mother.
Oh, yeah. Yeah.
You know, I can't hate women. I just treasure them. I have sisters.
Yeah.
Now I sound like the president.
Yeah. Right. I know. Yeah. I
cherish women.
Cherish them. Women. I cherish them, and so I don't want them to.
I cherish them. I grab them by the pussy. All right. Yeah. Moving on from him.
Yeah. Can I actually say something though? I've actually really been grappling. I mean, as an employment lawyer, I've been really grappling with that manifesto and what Google as an employer should have done about it. And I think, just my 2 cents for what it's worth, I guess, is they had to fire him because they are currently under investigation by the Department of Labor for pay inequities. And they got really bad press when they refused to turn over reams and reams of pay data because they said it would be too burdensome to put together. They just can't have this guy and this manifesto hanging out there without something really definitive. But I also think that I hope it's not the only way they're responding to him, because that guy is everywhere at Google. That guy is everywhere in Silicon Valley. And they can't all be
Wall Street.
Everywhere.
Like,
that's
yeah.
right. You know,
politics.
Yeah, they're everywhere. And so the answer as an employer, not speaking as, you know, should we sue and, you know, the sort of larger gender equity principles, but purely as an employer, how you deal with that is that you audit your compensation and evaluation procedures. And I guess the thing that was so alarming about this at Google is that even though this guy wasn't a supervisor of anybody where he could really do harm to someone's career, they have this special peer review process for promotions and pay. And, no one's going to ever, want to have this guy analyzing them. But the thing is, there are a bunch of him making these kinds of peer review decisions. And so what it should be is a teachable moment for reviewing their practices, making sure that people are questioned about their evaluations and that they get training in, how to make equitable decisions. And that dissent about diversity is not squashed, but examined, and also, constantly interrogated to be sure it's not infecting decision making. But to think that just firing this one guy is going to do anything, it's a myth, or it's a myth.
So why is it that even though these women that you write about in your book had such wins and worked so hard, this is still such an intractable problem, whether it's underrepresentation at places like Google, outright discrimination? I mean, it's been more than a half century, right?
Yeah.
Why are we still dealing with this shit?
That should have been the title, I think, of the book.
I mean, I know you want to celebrate them, but I guess since
yeah.
you're in the trenches every day, so you
Right.
also have an insight on the contemporary, the places in which the law has not given everyone redress or changed the culture.
Yeah. I think, I mean, if I had all those answers, I wouldn't have a job anymore, I think you hit the nail on the head when you use the word culture. There are certain places that the law has to go to still take account, for instance, of the concept of intentional discrimination, which is what Title VII prohibits in part. I think most people, at least, I don't want to say most. I think a lot of employers and a lot of people in the workforce today don't think that they're racist or sexist. They're not conscious of these feelings, but the paradigms that we have to judge these cases really require a showing of intent as opposed to something subtler like motive. So I think that's one thing, is that attitudes take a really long time to change. And secondly, I think we've got a crisis of leadership especially when we come to something like sexual harassment, which is so intractable and is so pervasive, whether it's at Fox News or Silicon Valley or in the fields that farm workers toil in. I was at an event recently where I met Bill Tamayo, or talked with Bill Tamayo, who's the regional attorney for the San Francisco office of the EEOC, and he said, in California, we've got it all. We've got the farm workers who are virtual slaves, out in the fields, away from any sort of support system, away from any sort of understanding of what the law protects, terrified they're going to be deported and, raped on a routine basis. So much so that one particular workplace was I don't know the Spanish in translation, but was called the Field of Panties because so many women had been raped there. And then we have Silicon Valley, where we have people at the highest echelons making the biggest salaries in this country who are also engaged in terrible abuse. And so when you have it that pervasive across economic levels and industries, it really is something deeper in our culture. And I think the only way is by having employers take aggressive action, make it priority one, create complaint mechanisms and investigatory mechanisms that work, that do not, result in retaliation, and also that men, when they're in rooms with other men, are taking a stand on this. I think I said this to you when we were preparing. I am so sick of talking to rooms of women about this problem, and I know the women I talk to are so sick of going to all of their women's affinity groups within their, companies or bar associations or whatever to talk about the same problems.
Got a pretty nice mix here.
Yes, I'm
Shout
happy
out
to
to everybody.
Right, I'm happy to see some male allies. Thank you very much for coming out. Yeah, great place to meet women if you're so inclined. Also. Just saying.
And if the women are so inclined.
Yes, of course. Of course. I'm so glad you're tempering all of my off the cuff, no means no, yes means yes. So why do we still have these problems? We still have these problems because the people at the top can get away with not fixing the problems.
And the people at the very, very top have the same kind of impunity.
Yeah. That's,
right. I mean, you were saying, farm workers, Silicon Valley, Wall Street. You mentioned politics, the set of The Apprentice, real estate, the White House potentially.
Yeah, the military. I mean, and it's just all about response from the top. And I told you I was at this event and met the guy who's the head of the litigation department at Paul Weiss, which is doing all the investigations of all the Fox, allegations. And you know, once Paul Weiss was brought in and it was clear that Fox was actually going to be doing something about this, the people started coming forward. Megyn Kelly, the biggest star at that, you know, network, hadn't said anything for years about what Roger Ailes had done to her. But when it's clear that there's some safety because the people at the top are saying, we want to know what you have to hear, suddenly the stories start coming out. And I think that's a real lesson to other managers, to other heads of organizations about how you bring this stuff into the light and end it.
There's a sense that I feel like, having been covering these issues for a while, it feels like we keep having to kind of reinvent the wheel. Like, right now there's a conversation about sexism in Silicon Valley or in television, and you read about or watch the hearings of Anita Hill, and everybody was like, wow, there's such a thing as sexual harassment, and now they're like, wow, there's such a thing as sexual harassment. You know, like, we keep having to relearn these lessons, and people keep having to sort of rediscover these deep inequalities along the lines of gender or race, and so on. What did you feel like going into the history of it? What did you learn from the women and from their stories that you didn't know before? That could help us kind of have a little bit more historical memory as we keep having to relearn these difficult lessons, that things are being torn apart in ways we're not talking about.
Right. Well, I was prompted to write the book because I sort of had this realization one day that as an employment lawyer, there are certain cases that I rely on just that are sort of brand names. You know, if someone has a sexual harassment complaint, oh, well, that's Meritor v. Vinson, involving the case of Michelle Vinson, who was a 19-year-old bank employee who was basically raped by her supervisor for 3 years. But didn't have damage to her pocketbook, never lost her job. So that's why the court sort of struggled with what to do with her. And then eventually the Supreme Court did find that hostile work environment harassment is illegal. But there were these brand name cases, but I actually didn't know anything about the people who had brought them. And moreover, you know, they didn't have the brand name cases to rely on. They were, as I mentioned at the start, sort of making up this law as they went along. And that was just incredibly interesting to me because I knew how brave my own clients were, who at the time were construction workers and firefighters, and the kind of retaliation they faced for stepping forward was just horrible. And so I was really interested in knowing who these women were. And what I found, and almost 2-1, the one exception being Michelle Vinson, who did not respond to me, which I do not begrudge her at all, and can completely understand that she had no interest in revisiting this period in her past, which at that point was 30 years prior. But 2-1, they were all, to almost 1, they were very forthcoming and interested in telling their stories, in part because they had not really been covered all that much. The cases were covered as Supreme Court decisions, but they weren't covered much the same way that, like, Peggy Young's case was covered as about Peggy Young. Although
maybe they were lucky that it didn't end up being about them, and that they didn't have as much scrutiny.
That's a very good point. Yeah, it is definitely a double-edged sword, that kind of publicity, and certainly, you know, at least in those days they weren't dealing with you know, Twitter and social media and all the, you know, all the vitriol that can be directed at them. But pretty much 2-1, they certainly never expected that they'd end up in the Supreme Court, or that their court battle would take so long. I mean, most of them, it took 6-8 years. But also they were pretty, you know, ordinary. Like, virtually none of them considered themselves feminists or had any sense of themselves being tethered to a larger movement. You know, Ida Phillips, who I mentioned, who was denied a job for being a mother of a small child, you know, she read the newspaper, but she never, there was one time after her case had been brought, her daughter insisted she go to a NOW rally, you know, and she was sort of like, well, I hope they're not going to be burning bras and things like that. Like, she, you know, she had brought this case that was going to the Supreme Court, but meanwhile she, you know, didn't identify with a larger feminist movement. Same thing with Kim Rawlinson, who brought the prison guard case. Very alone, you know, very no support from her family, who were embarrassed that she was doing this. But she was just, in her words, pissed, just pissed. and it wasn't right, and she wanted to pursue it. And I think, frankly, it also, at a time when she did not have a lot of people telling her that her life was all that important, it felt pretty important to be doing that. Yeah, I mean, I think that's the common thread is women being really pissed and wanting to see if they could do something about it.
Not being afraid to come forward.
Yeah.
Even though it could have cost them a lot.
Yeah, I think probably most of the women didn't understand how much it could cost them because they didn't understand how long it would take. It was more just they're going to call a lawyer and, you know, see if something can get done. One person who did very much understand what was going to happen to her was Ann Hopkins, who in the early 80s was a consultant at Big 8 accounting firm Price Waterhouse, and she went up for partner in 1982. She was the only woman out of 88 candidates. Had the biggest book of business of any of the candidates, and was denied partnership or deferred for the following year. And when she met with the head partner of the firm to find out why that was, he started reading her the evaluations from the partners who had considered her and turned her down. And they said things like, macho, needs a course at charm school, overcompensates for being a woman, swears too much for a lady partner. And then she went to her mentor at the firm and said to him, none of these are about my skills or about my performance or the business I bring in or whether my clients like me. This is about just me, who I am. How do I fix that? And he said, well, why don't you try to walk more femininely, talk more femininely, wear makeup, get your hair styled, and wear jewelry. She bought a pink suit. She did try. Not surprisingly, it made absolutely no difference, and she was not even put forward for partner the next year. She knew quitting and suing Price Waterhouse was, if she didn't win, likely the end of her career. And she, in fact, for the whole duration of the lawsuit, was basically a consultant who made her own way. But most of the others, I think, got into this not understanding the toll it would take. And sadly, in most situations, except for Ann Hopkins, in most of the situations, the women had very little to show for it at the end. I guess Peggy Young ended up settling with UPS for a handsome amount. But Ann Hopkins was the first person actually to be installed as a partner as a remedy for a discrimination case. So she went back to Price Waterhouse 8 years after she had first tried, and stayed there for another decade and then retired. But yeah, so the toll that it took on the women and what the path was going to be like, most of them never understood.
We're going to open up to questions shortly, but I do want to ask you a little bit about the kind of intersectional implications of Title VII, because it's interesting, right, that it was born out of white supremacy, basically.
Yeah.
Women's rights, white women's rights advocates, pairing with white supremacists. But then I learned from the amazing biography of Polly Murray that, you know, you talk about this, the National Organization for Women in part was founded to defend the sex provision, which was basically just being ignored and not enforced. And Polly Murray gave an interview and she said, how am I supposed to know if someone's discriminating against, and this is, if you don't know who she is, I really recommend The Firebrand on the First Lady, and there's a new book out this year, Jane Crow, that's also great. Polly Murray was a legal theorist on the board of the ACLU who inspired Justice Ginsburg. And she said, how am I to know if someone is discriminating against me because I am black or because I'm a woman? And she might have also added because her gender identity was, perhaps today we would think of her as trans, or she would think of herself as trans, and because she was attracted to women. And so ways in which all of these different provisions kind of work together. And today still is very much a live question, of course, whether this includes gender identity, whether it includes sexual orientation discrimination. So I wonder if we could just sort of like be a little bit more forward-looking to think about how is Title VII being used now? How can it be used? How is sort of like the present DOJ, just a short overview for the non-lawyers in the room about this, the continuing evolution of the understanding of Title VII.
Yeah. Well, in fact, Ann Hopkins' case, which I just mentioned, the one about walk more femininely, talk more femininely, the takeaway from that case that was so significant and has such relevance still today was that the Supreme Court, her lawyer used a social psychologist to help explain to the court, and there weren't juries under Title VII until 1991, so it was a judge who they had to convince, to explain to the court that this reliance on stereotypes about what women are supposed to be like and what they're not supposed to be like was a form of discrimination, even though they weren't saying out loud, we don't want to promote her because she's a woman. And so what the Supreme Court's holding ultimately meant, which was revolutionary, was if you denying Ann Hopkins' partnership for being the wrong kind of woman was indistinguishable from denying her partnership because she was a woman. And that elevation or recognition of stereotypes as discrimination has set the stage for trans and LGBT workers as well as students, because Title VII informs a great deal of how Title IX, the education context, is interpreted. Interestingly, for all of the horror that trans individuals and the indignities that they're facing in the public accommodation spheres, like all the bathroom bills, which are so, so humiliating and offensive. In the employment realm, they've actually fared better within this stereotype frame. And LGB workers have had a harder time, but we're at a really, really pivotal point. Employers have had an easier time understanding failure to conform to a stereotype that's visible to them as opposed to one that's about identity. And so we're at a kind of an important trigger point now, because the country is divided into 11 courts of appeals, 12 if you count the DC Circuit, and they cover different geographic areas. And the Seventh Circuit, which covers some states in the Midwest, in April issued a decision from the whole court, not just a 3-judge panel, that discrimination on the basis of sexual orientation is discrimination because of sex under Title VII. The 11th Circuit, which covers some southern states, including Georgia, where the case came from, said, no, it doesn't. The Second Circuit is about to revisit that issue, and if you really want to nerd out, oral argument is September 26th here in New York at the Second Circuit. I will be there for sure. And they're going to be considering that question and revisiting old precedent. So
we might get a chance to find out what Justice Kennedy thinks about this.
And so Lambda has appealed the 11th Circuit bad ruling to the Supreme Court, and it's not clearly an effort to get this in front of a court that has Justice Kennedy on it. It's not clear if they're going to grant certiorari, which is what it means when they agree to hear a petition. But that is, the opponents say, well, I mean, they weren't Congress wasn't thinking of this when they passed the sex provision of Title VII. I mean, as we've heard, they were barely thinking of anything at all when they passed it. So how can we, expand it beyond its, original form? And the answer to that in the ACLU, I'm very proud, has submitted a brief over and over again in these cases with our LGBT project, surveying the development of Title VII's sex provision and the fact that it has expanded in ways that the Congress never could have thought of, because of course Congress wasn't thinking of LGBT people. LGBT people were still being thrown in jail in 1964. But Neither did Congress envision
Hostile work environment.
yeah, sexual harassment. Neither did Congress envision same-sex harassment, which has also been found in an opinion by Justice Scalia, by the way, to violate Title VII. Subgroups of women, which gets to the intersectionality issue that you discussed. The Martin Marietta case. Ida Phillips was a woman, but she was a woman with children. The company's defense was, we hire 70% women. How can it be sex discrimination? It's just this subset we don't hire. The court said, even if it's a subset of women, if it's because she's a woman, then it's sex discrimination. Similarly, women of color have been able to use that moving forward. Anyway, so
and she was represented by the NAACP, which is
yes.
an awesome kind of
yes.
way that all of these issues really can't be
yes, because
separated.
Ida Phillips was white, but the majority of working mothers at that time and today were African American women, and the NAACP Legal Defense Fund understood that the law was going to mean nothing ultimately if any one of the protected characteristics could be used to screen people out if some sort of benign plus factor was added on. You know, blacks who are left-handed, we won't hire them. You know.
Well, we didn't say no girls allowed, so it's okay. Okay, everybody, you should read Because of Sex. Thank you so much.
Thank you.
And we'll take your questions, too.
If you want to raise your hand, I'll bring you a mic. I know it's hard to go first, but good on you.
Hi.
Hi.
So obviously you spoke a lot about how most of the women in the cases that you were focusing on in the book are normal women, not necessarily part of a larger movement. How do you think things would have progressed differently if they had had the support of the feminist movement, however you want to define that, and if they had been more deliberately put in the spotlight in the way that, for example, like Rosa Parks was chosen by the NAACP? Do you think that would have made any sort of difference in the way that we've developed?
I mean, hypotheticals are always hard. I can say for sure that I think that these women, and I've seen with my own clients who have greater support systems and feel part of something larger, I think the individual women I met would have felt less alone and just felt more supported and sort of been less traumatized by the experience.
Did
for
the
sure.
movement never show up for them?
It always showed up at the amicus brief point, and then it was rallying around the lawyers. I'm sorry, friend of the court briefs are filed when cases, I mean, they can be at lower court cases too, but I'm referring to when cases went to the Supreme Court. There was actually a common, and you probably encountered this with your research on Justice Ginsburg as well. There was a common arc where you had this small town lawyer, like in Ida Phillips' case, someone from Jacksonville, Florida. In Teresa Harris's case, a lawyer from Nashville who had only done a couple of employment cases. They stick with their clients, through thick and thin and the losses for several years, and then cert gets granted and the Supreme Court decides to hear the case, and suddenly the phone was ringing off the hook from the ACLU Women's Rights Project or
Bunch of carpetbaggers.
Yeah, that's right. Exactly. Total carpetbaggers. And they're saying, why don't you let us argue? And it can be, or National Women's Law Center, all of the national groups, have made these phone calls, and it creates some tension. So, but on the other hand, those amicus briefs that are submitted make a huge difference. I think they made a big difference in the Young versus UPS case, for example, which was very much embraced by the women's community, women's advocacy community. And also, interestingly, by the anti-abortion movement, because because women who are denied a workplace accommodation that would allow them to keep working, if they're faced with losing their job or having the baby, they're going to have an abortion, a lot of them. I've certainly had clients who have considered going that route. And so there were 25 faith-based organizations and anti-abortion organizations that submitted briefs. I think the experience of the years of litigation before the spotlight of the Supreme Court is on them would have been less painful. And then there are only 2 cases in the book that came out of real sort of concerted, strategic efforts, and one is the case I mentioned about the pension, where it was actually the International Brotherhood of Electrical Workers at the Department of Water and Power who had all the technicians who worked at the department were unionized by the Brotherhood, International Brotherhood, but it was the clerical workers who were eligible to be unionized, and the Brotherhood wanted to attract women, and they had to show something about caring about women's issues, and they brought this litigation to challenge that pension deduction. The Johnson Controls case I mentioned with the fetal protection policy, that was, I have to give a shout out to my current employer, ACLU Women's Rights Project. They were very much at the forefront of identifying these fetal protection policies as popping up all over the country, basically as backdoor ways of getting women out of jobs that they had just started entering due to enforcement efforts of the 1970s and of the Carter administration, Department of Labor especially, and the EEOC. And that was very concerted, and a woman named Joan Burton, who was there, worked tirelessly to get together this coalition of doctors and scientists and lawyers who could and ethicists who all kind of helped the lawyers who worked on these cases understand them, and also come up with sort of a template, a litigation template for going around the country and challenging these and helping create the circuit split that ultimately drove the case to the. So I think some of these problems could have been addressed quicker if there was more buy-in from all different sectors and litigating as a movement. That's really hard to do, though. I think that was sort of a magical, perfect storm that she helped engineer, and that the project helped engineer.
Another question over here.
Hi.
Hi.
So you actually already started to go there, but I was going to ask you about abortion. I recently graduated college, and I had to complete an undergraduate thesis, and it was on contemporary issues of abortion access in Pennsylvania, where I went to school in Ohio, right next door. And one of the questions that I looked at but didn't get very deep into was about waiting periods and how those can affect a lot of different things, such as transportation, such as employment, such as other kind of monetary factors. So I don't know if this is something that there's maybe precedent for on a larger level, or if it's an issue that's going to come up as sort of more abortion laws are popping up, as more trap laws are popping up specifically, where waiting periods are going to get longer and clinics are going to be shutting down more, and so it's more likely that someone would have to, say, cross state lines or take multiple days off, or things like that.
That's a fascinating question. I mean, just on a sort of basic Title VII, what's the law level? The Pregnancy Discrimination Act was enacted in 1978 to amend Title VII to make clear that sex discrimination included discrimination on the basis of pregnancy or childbirth or related medical conditions. Abortion has been interpreted as one of those, related medical conditions or because of pregnancy. So, for instance, if a woman gets an abortion and her employer learns about it somehow, say because she needs a couple days off to recover, and is fired or other adverse action is taken, that can violate the PDA. Similarly, treatment for infertility, if someone is denied access to time off to go to medical appointments to receive treatment for IVF or other kinds of treatment, and that is different from how others with medical conditions are treated, then that also can be a violation of the law. So just with that sort of basic outline, I mean, I think what you're talking about is really a variant of the accommodation question, a variant of, it's sort of Peggy Young, a few years down the line. And in other words, will employers be violating Title VII if they don't give women the accommodations they need to go get that medical care? And unfortunately, it's a real shortcoming of the Pregnancy Discrimination Act that, and it's way in the weeds and beyond the scope of tonight's discussion, but the way it was enacted was to grant pregnant women comparative rights in the workplace. In other words, there was so much fear in 1978 about creating anything that looked like special rights for the reasons that Irin was talking about historically, that the framers of it wanted a very strict equal treatment approach, so the Pregnancy Discrimination Act, part of Title VII actually says women are to be granted employment-related benefits the same as coworkers who are not pregnant but similar in their ability or inability to work. So sadly, that means that pregnant women's rights in the workplace are tethered to whatever the employer may grant non-pregnant workers. And so if the non-pregnant workers are treated like crap and they don't have any sort of paid disability time off program, for instance, then they don't have to provide that for for pregnant women either. So that's my roundabout way of saying, I think a case like that, if someone were in Ohio and needed 3 days to take off and go, it would really depend on the kinds of time off that others were given for other personal or medical purposes. But it's a hard question.
Right, and I think more broadly, because of the sort of historical contingencies that you're talking about, that abortion law has developed really separately from the employment discrimination laws that we're talking about, and even from the broader constitutional questions of sex equality, something that Justice Ginsburg was very upset about. But because everything in the Supreme Court is about precedent, sort of the line of cases, abortion has kind of its own planet and its own rules, and there have been very good arguments made that something like a waiting period is operating under the same stereotypical assumptions of women's decision making that we were talking about in all of the cases related to Title VII. So, for example, like why only when women, like a surgery that only women or people with the ability to be pregnant have, only this requires a waiting period like this. Only this requires all of these kinds of hoops that women have to jump through.
They're neurotic and anxious.
Right, and they change their minds, and they don't know what they want, and they don't understand that it's a baby, and all of these assumptions that are inherent, and you can find Justice Ginsburg talking about this in her dissent from a different abortion restriction. These are all related to the same reasons why the women that you wrote about were treated the way that they were, but because of the way the Supreme Court and the law works, they've kind of like evolved separately, and there hasn't yet been enough of a buy-in in the Supreme Court, let's put it that way. We haven't had the right court to say, actually, when you say that women are like, really can't make up their minds and need somebody to tell them more about what's happening, and we need to someone needs to tell them that abortion causes cancer, even if it doesn't. That's the same thing. That's the same kind of like romantic paternalism gone wrong, and unfortunately, that's not the kind of legal history or the current court that we have.
It's very cobbled together. The sex discrimination, sex equality law, and part of it's decided under the Constitution, which involves state action, like laws against pregnancy, laws against abortion, or laws regulating abortion, whereas Title VII is about private employer action. It's not under the Constitution. It's all very...
It doesn't make any sense,
no,
right? But this is
no.
just the
Right.
way we have it.
Right, but they're animated by all the same biases.
More? Okay, we have time for one more. Yes. I feel like I've been neglecting this side of the room.
We can do 2 more. We can go a little
We'll
over.
do 2 more.
All right, well, so I recently read the statistic again from Fortune and Forbes that actually less than 10% of all VC funds go to companies which are female-led. So maybe from your perspective or your expertise, what tips and tangible tips could you give for a strong female entrepreneur to go for venture capital funding on how to get one? If that's not too far off.
Well, you don't. If you want to not limit it to VC, that's okay too. You could think about sort of underrepresented in general.
Yeah, women really are in a bind. I mean, thinking about back to Ann Hopkins and the advice she got about being softer. There was just a study that came out of Australia. I mean, file this under, did we really need a study to tell us this? But that women are judged on likability. And that the whole, the concept of the double bind is alive and well in terms of, be forceful and say, you should give me your money because I can do X, Y, and Z. You risk being seen as a ball breaker and not likable. And so, are you going to lose the funding because you weren't likable enough, even though you're, off the charts competent? So, I think that there are lots of guides out there. I know Sheryl Sandberg tried with Lean In to sort of talk about this, and there are other other people who've made a cottage industry out of telling women how to get what they want and not offend anybody at the same time. And I'm not expert in that, but I think from what I understand, it's very much based on, stressing competence while also stressing willingness to listen, stressing competence, but while also conveying warmth. I don't know. It's hard.
How are we doing? Are we conveying warmth?
Yeah. I feel very warm and cozy in these seats.
I know, right?
If
I'm going
these
to curl
could
up
be,
here.
Yeah.
Okay, last question. Yes, you in the red.
Hi. You can project.
I can project. Can you hear me?
Yes.
So I was wondering, I understand that civil law, that Title VII doesn't necessarily impact the military, but could you speak to what it does and doesn't affect, and if there's been cascade effects, or can you speak about the military and women and employment that way? Is there?
Sure.
Thank you.
And I'm also looking at my my predecessor at the ACLU Women's Rights Project, Ariella Migdal, who spearheaded and brought to fruition our litigation to open all combat jobs to women in the military. So I inherited that case, but that was conceived by Ariella. And yes, it's a woohoo moment. And while the military didn't, while Leon Panetta in 2013 didn't say, gee, the ACLU has brought to my attention that it might be unconstitutional for us to not allow women into these close to 500,000 jobs that are designated as combat jobs. The policy was lifted in 2013. That kicked off a long period of studying how to incorporate women into these positions. And the litigation remains still open because we have been monitoring and giving periodic reports to the court about how the integration process is going. And there are some things that are still of concern. For instance, again, the stereotype thing keeps coming up. For instance, both the Army and the Marines now have a policy called Leaders First, meaning that women, junior enlisted women, will not be placed in a formally closed unit until at least one or two, depends, the services have different numbers, one or two women leaders have been in place for 30 to 90 days, so as to, integrate the unit somehow and make it friendly to them, as though male leaders are off the hook for having to change the culture themselves, that instead it's up to these, individual ladies to come in and make the place more welcoming. I mean, obviously having women in top positions, I think we can all agree, is an important goal, but to actually impede women's entry into these units until that person can be installed seems unduly restrictive and also likely to delay women's entry into those units. Additionally, the Marines still segregate their basic training, which we also think is unconstitutional and certainly sets a tone for second-class status that I think the Marines United Facebook page scandal is sort of the natural evolution of. So Title VII does not apply to the military. It's the Constitution, but even under the middle level of scrutiny that equal protection provides under the Constitution for sex-based characteristics, I think we've been dealing with pretty overt bans. And then the one other thing, I think people know about the transgender. I think it's been sufficiently debunked that a tweet does not change the policy of whether transgender individuals are accepted into or allowed to continue serving. Roughly as many as 15,000 are serving now. So that has been delayed somewhat. There's been a 6-month period of further study of how to assure seamless entry of trans soldiers into the force, as opposed to those who transition while they're in. So that was dispiriting that was announced. But the idea of an outright ban I mean, we will certainly fight it. The ACLU will, and I think it's going to be harder to be implemented given the status of current law.
Thank you so much, everyone. Really appreciate your engagement.
Thank you, Irin.